There are moments in a courtroom that no amount of legal training prepares you for. Moments where the air shifts, where reporters stop typing, where even the judge pauses and stares. This was one of those moments. A 13-year-old boy stood before the bar of justice. 94 pounds, dark hair combed neatly, a pressed shirt 2 sizes too large hanging off his narrow shoulders, and he smirked. Not a nervous twitch. Not a misread expression from a scared kid overwhelmed by adult proceedings. A slow, deliberate curl of the lip, aimed at no one and everyone, the expression of someone watching a film they had already seen and already knew the ending to. The courtroom went cold. He was 13 years old. He had been alive for fewer than 5,000 days. And in those 5,000 days, 2 people who loved him, who made him breakfast, who taught him chess, who cleaned out a spare room and bought new bedding and chose, with open eyes, to bring him into their home, were now in the ground. 11 days in the ground. Because of him. The smirk said he knew it. The smirk said he did not care. And then the judge, a woman who had spent 19 years on the bench without ever once pausing mid-sentencing to address a defendant the way she was about to address this boy, leaned forward and removed her glasses. What happened next would be recorded on 3 separate courtroom cameras and watched by 14 million people within a week. But to understand what the judge said, and why the courtroom shook when she said it, you have to go back. Back past the verdict. Back past the trial. Back past the investigation and the search history and the text message sent 90 minutes after 2 people died that consisted of a single lowercase word, done. You have to go back to a quiet street in a mid-sized American city, to a house where someone had made oatmeal with brown sugar that morning, to a chess game left mid-move on a dining room table, to 37 journals stacked on a hallway shelf. You have to go back to Harold and Evelyn. Because this story belongs to them first. Pushpin stories like this remind us that justice always finds its way. If you believe in accountability, subscribe now and share your thoughts below. The forensic thread that would unravel everything was hiding in plain sight from the first hour of the investigation. A phone, cheap, prepaid, the kind sold at gas stations, sat face down on a nightstand in the boy's bedroom when officers arrived at 1:31 in the morning. When forensic technicians extracted its data days later, they found the text sent at 11:47 p.m., the search history spanning 11 days and something buried even deeper. A record of who this boy had been preparing to be for months before anyone realized he was preparing at all. He thought the phone kept no records. Kept everything. Harold Marsh was 68 years old and had lived in the same house for 31 years. He had worked as a machinist for 26 years, retired, and spent the decade that followed turning his garage into a wood-paneled workshop where he restored furniture for neighbors who couldn't afford antique shop prices, and never told anyone about it. He smelled like sawdust and coffee. He wore the same brand of work boot for 40 years and bought them 3 pairs at a time. His neighbors described him with the particular warmth that people reserve for someone who asks about your life and actually waits for the answer. Evelyn Marsh was 65. She had been a school librarian for 18 years, the kind of librarian who could look at a child for 30 seconds and know exactly what book they needed, not just what book they wanted. She read 3 novels a week. She kept a journal, 37 volumes of them on a shelf in the hallway, each one dated, each one dense with the particular kind of attention she gave everything. Careful, curious, warm. She sent birthday cards by mail. She had been teaching her grandson chess in the evenings, and she had told her sister over the phone, in a call her sister would remember for the rest of her life, that she was genuinely proud of the boy's sharp mind. She believed he was going to do something meaningful with his life. The boy had been living with Harold and Evelyn for approximately 8 months at the time of the killings. The arrangement had been made after instability in his primary home, details that are part of the court record and will be addressed when the time comes. What matters here in this chapter is that Harold and Evelyn had not hesitated. They had not waited or delayed it or asked for time to think. They had cleaned out the spare room, bought new bedding, enrolled him in the nearby school and brought him home. They had chosen this. That choice is the foundation everything else is built on. 3 weeks before the killings, Evelyn had framed the boy's school photo, blue shirt, neutral expression, the look of a kid told to smile one too many times, and placed it on the mantel beside Harold's retirement photos and a grandchildren wall that stretched back 20 years. It was still there when officers entered the house. It would still be there when the house was sold. The community's grief, when it came, was the kind that a neighborhood carries without knowing where to put it. Neighbors left flowers. The church Harold and Evelyn had attended for 22 years held a memorial that the pastor, by his own admission, could not adequately prepare for. He wrote it 4 times. None of the drafts felt sufficient. The school where the boy had been enrolled held a moment of silence that was uncomfortable in the specific way that silence becomes uncomfortable when no one is quite sure who they are mourning for and who they are horrified by. Investigators, combing through the house in the days after the killings, found Evelyn's journal on the nightstand, the 38th volume, half full. The final entry, written 2 days before her death, noted that the boy had seemed distant at dinner and that she planned to call the school counselor in the morning. The last line read, "Something is off. I'm going to find out what." She never made the call. The journal entry became Exhibit 14 in the prosecution's case. The defense requested its exclusion. The judge denied the motion without elaborating. The chessboard was still set up on the dining room table when officers arrived. Mid-game, pieces in play, the boys' side arranged in an aggressive formation. A forensic photographer documented it without understanding its significance. That significance would surface 3 weeks later when the grandmother's sister found a photo taken 6 days before the killings showing the board in the same position. They had been playing the same game for nearly a week. It was never finished. Tucked inside a kitchen drawer, already wrapped, was a birthday card Evelyn had bought for the boy's upcoming birthday. It read, "We're so glad you're here." It was a Thursday. Harold had finished in the workshop around 8 in the evening and come inside smelling of sawdust and varnish. Evelyn had made chicken noodle soup, her default on cold nights. The three of them ate together. A neighbor walking a dog at approximately 8:45 p.m. reported seeing the front room lights on and what appeared to be the television playing. She did not stop. She had no reason to. Everything looked exactly the way it always looked from the outside. That was the last verified external observation of Harold and Evelyn Marsh alive. The house, as investigators would move through it in the early morning hours, told a story of an ordinary evening abruptly interrupted. Dishes in the drying rack. 2 remote controls on the armrest of the sofa. Harold's reading lamp left on beside his chair. The workshop tools hung in their designated places. Harold was meticulous about that. A project half finished on the bench, sawdust still fresh. The kitchen counter with the oatmeal bowl. Every ordinary detail became, in the context of what had happened, a kind of monument. The house looked like a house where people were sleeping. Not a house where people were gone. Harold kept a legally registered firearm in a lockbox in the bedroom closet. The boy knew where the key was. Harold had told him, in a moment of trust that Harold had described to a neighbor as teaching him what responsible adults know, where emergency items were kept. The lockbox was found open. The weapon was recovered. Forensic analysis, blood spatter patterns, trajectory reconstruction, time of death calculation, placed the killings between 9:30 and 10:15 that evening. The sequence of events, reconstructed from forensic evidence, was methodical. Harold was killed first. Evelyn's injuries told a different story. She had been in motion when she was killed, moving toward the sound rather than away from it. Because it was her house. Because in 31 years of living in that house, nothing had ever required her to run away from a sound inside it. She had no frame of reference for what was happening. She moved toward it the way she had always moved toward difficulty. Directly, with the assumption that moving toward a problem was how you solved it. That detail belongs to her. It is the most Evelyn detail in the entire case. Between the estimated time of death and the text message, sent at 11:47 p.m. 90 minutes later, there is a window. Investigators reconstructed the boy's movements during it through phone data, internal timestamps and partial later admissions. He did not call for help. He did not leave the house in panic. Phone records show activity consistent with someone awake and deliberate. He changed his clothes. He appeared, based on every available piece of evidence, to have spent 90 minutes in a house with 2 people he had killed, doing something other than grieving. The word "done" was sent at 11:47 p.m. to a 16-year-old he had met through an online gaming platform. One word. Lowercase. No punctuation. The call to emergency services came at 1:14 a.m., not from the boy, but from a neighbor across the street who had been woken by a sound she couldn't identify and then found the silence that followed it more alarming than the sound itself. She called it in as a welfare check. Officers arrived at 1:31 a.m. Quiet street, house lights on, no visible disturbance. The garage door was open. Harold's truck sat in the driveway. One officer knocked twice, announced himself, tried the door. It was unlocked. What he found inside would stay with him for the rest of his career. The boy was in his bedroom. Awake. Sitting on his bed. Come. He told the first officer he had heard noises but was scared to check. He said it with steady eye contact and a level voice and no tears. The officer, 12 years on the job, trained to read effect, later testified that his immediate instinct told him something was wrong with the boy's face. Not his story. His face. He looked, the officer said on the stand, like someone watching a movie they had already seen. When forensic technicians later opened the phone found face down on the nightstand, they found not just the text message but a browser history that made the movie metaphor precise. He had known exactly what was coming. Because he had written the script. Within 24 hours of the discovery, detectives had executed a search warrant for every digital device in the house. The boy's phone was the primary focus. It was a cheap prepaid model, the kind teenagers assume doesn't keep records. This one kept everything. Forensic technicians worked through the night, and by the following morning they had a document that the lead detective later described as the most complete window into premeditated intent she had ever seen in a juvenile case. It would become the spine of the prosecution's argument and the central problem of the defense's. The browser history covered 11 days. It was organized, in retrospect, like a research project. The searches fell into 4 categories that the prosecution would present to the jury as a sequence: methods of causing death without detection, legal consequences for minors in the state, inheritance law as it applied to grandparents, and the search that stopped the room when the detective read it aloud: how do people act when they are innocent? That last search was conducted 4 days before the killings. He was not researching innocence. He was researching how to perform it. He was preparing for the role before the play had even opened. The text message thread with the 16-year-old out of state told a longer story. Investigators obtained a full extraction of the conversation. In the weeks prior, the boy had discussed, in varying degrees of directness, his frustrations with the living arrangement. He described Harold as controlling, a characterization that Harold's friends, colleagues, and neighbors found, when later interviewed, genuinely bewildering. He described Evelyn as someone who asked too many questions. He said he wanted to leave. When the other teenager asked where he wanted to go, the boy's answer was direct: anywhere I'm in charge. Investigators pursued a financial motive early, because the search history referenced inheritance law and Harold and Evelyn had modest but documented assets: a paid-off house, retirement savings, 2 vehicles. But the deeper they went, the less the financial theory held. The boy was 13. He could not access assets, could not sell property, could not benefit in any near-term material way from their deaths. Which meant the motive was not financial. The lead detective, presenting this finding to the prosecution team, noted that the absence of a financial motive made the case both harder to explain and significantly easier to prosecute. There was no complex narrative to untangle. There was only what he wanted and what he did about wanting it. The investigation opened a secondary thread 2 weeks into the case. The school counselor had filed an internal concern note, not a formal report, a notation, about elevated aggression and flat affect, observed during a mandatory check-in session with the boy. The note recommended a follow-up evaluation. The evaluation had been scheduled. It was scheduled for the week after the killings. The outline of what might have happened, what the evaluation might have found, what it might have changed, sits in the case record as a permanent open question. The boy was interviewed 3 times in the first week. Both initial interviews were recorded. In the first, he maintained the story of hearing noises and being frightened. He was consistent and measured and, detectives noted in their reports, oddly focused on procedural logistics. What happened to the house now, when he could retrieve his belongings, what the next steps were. In the second interview, after investigators revealed the search history, his consistency fractured. Not into confession. Into a new version. A revised account that attempted to incorporate the evidence without acknowledging what it meant. Experienced detectives recognized the pattern immediately. This was not a scared kid recalibrating under pressure. This was a strategist adjusting his position. By the third interview, conducted with a juvenile advocate present as required, the boy made what the prosecution would characterize as a partial admission. He acknowledged being present during the events. He did not say he caused them. He did not express grief. When the detective, choosing her words with precision, said that Harold and Evelyn's family needed to understand what had happened, the boy was quiet for a moment, then looked at the ceiling and said, "People die." The detective maintained her composure in the room. Later, she told the prosecutor that it was the hardest professional moment of her 20-year career. The forensic lab results arrived the following morning. Gunshot residue confirmed on his hands and forearms despite evident attempts to wash it away. The detective received the report at 6:47 a.m., standing in a hallway outside the lab. She called the prosecutor before she reached her car. Charges would be filed before noon. The court-ordered psychological evaluation took 40 clinical hours across 3 weeks. The forensic psychologist who conducted it had evaluated more than 200 defendants in her career, including adults convicted of first-degree murder. She said afterward that this case required her to write and rewrite her conclusions more times than any other in her professional life, not because the findings were unclear, but because putting them into language that a courtroom could receive required a kind of precision that the clinical vocabulary alone could not provide. Her findings placed the boy in the 94th percentile for callous unemotional traits on standardized assessment tools. For reference, she explained during testimony, the average incarcerated adult murderer scores in the 71st percentile. The designation, callous unemotional conduct disorder, carries specific weight in juvenile proceedings because it speaks directly to the question of rehabilitation. It describes not impulsivity or rage but something colder, a functional absence of the emotional feedback that most human beings experience as a natural break on harmful behavior. He did not lack the ability to understand that what he had done was considered wrong. He lacked the architecture to feel it. The boy's background was documented by Child Services across 3 separate reports filed before his 12th birthday. His early years were marked by parental instability and absence, a pattern of adults who were sometimes there and sometimes not, whose reliability could not be counted on, whose presence did not consistently produce safety. Clinicians who later examined him described what they called instrumental attachment, a relational style in which other people are understood primarily in terms of what they provide rather than who they are. Harold and Evelyn had tried to rebuild something in 8 months that had not been built in the first 12 years. They were not wrong to try. They were working against a deficit they did not know the full dimensions of. Hidden beneath a false bottom in his dresser, investigators found a journal. Not like Evelyn's journals, not observation, not feeling, not the record of a person paying attention to the world. This journal was tactical. It contained plans, hierarchies, rules, a constructed world in which the author was the only authority. It described what his life would look like when he was, his word, free. The grandparents appeared twice in its pages, once as obstacles, and once in a notation made 6 weeks before the killings, simply as a problem followed by a listed solution. The solution was not vague. The solution was specific. The ink analysis confirmed it had been written 6 weeks before the events it described. What made the psychology of this case distinctively disturbing, and what made it so difficult for the community to process, was how seamlessly ordinary he appeared in daily life. Teachers described him as quiet but engaged. 2 friends from school gave statements, clearly at personal cost, saying they had seen nothing alarming, that he had just seemed like a kid. He complained about homework. He played video games. He asked a girl in his class if she wanted to work on a project together. The performance of normalcy was, the forensic psychologist testified, itself a clinical symptom. The completeness of the performance indicated not psychological health but the precise, functional absence of the emotional underpinning that makes performance feel like performance to the person doing it. For him, it was not performance. It was simply what was required to move through the world without friction. Multiple people who interacted with the boy described the same specific pattern. Cooperative with authority until that authority was perceived as limiting his autonomy, at which point something shifted, not explosively but completely. A former teacher described it as becoming a different person. Not angry. Cold. Harold's enforcement of normal household boundaries, curfews, chores, phone restrictions, the general architecture of a functioning home, had registered in the boy's internal framework not as care, not even as inconvenience but as siege. He experienced structure as an existential threat. The grandparents had been trying to build something. He had been dismantling it in his head since the first week. The forensic psychologist, asked directly on the stand whether the boy was capable of remorse, gave an answer that was careful and devastating in equal measure. She said that in 40 clinical hours she had observed 0 spontaneous expressions of grief, guilt, or loss related to Harold and Evelyn Marsh. She had observed, on 2 occasions, what appeared to be emotional effect. But on examination, both instances were triggered by discussion of consequences to himself, not harm to others. The distinction she made was precise. What the boy appeared to feel about the killings was not grief. It was inconvenience. Her written report concluded with the line that the prosecutor later read into the record. The defendant presents as an individual capable of understanding rules and consequences, but demonstrating a fundamental deficit in the capacity for genuine moral reasoning. He knows what wrong is. He does not feel it. The prosecutor had tried 63 murder cases in 20 years. She had sent people to death row. She had sat across from monsters who wept convincingly and killers who maintained innocence through 2 appeals. She had never faced a charging decision quite like this one, and she said so, in the privacy of her office to no one in particular, before she made it. The choice was binary but not simple: charge the boy in juvenile court, where the maximum outcome was release by age 21, or seek adult certification and open the door to life sentencing. It was a legal decision with a moral dimension she could not separate from the legal one, no matter how many years of practice told her to try. The public defender assigned to the case was experienced, principled, and honest about the terrain she was operating in. She did not pretend the evidence was weak. She did not pretend her client was misunderstood in the way that misunderstood clients present themselves. Her strategy, laid out in pretrial motions with precision and evident care, was to argue that the boy's age, his documented developmental history, and his clinical profile made adult prosecution constitutionally inappropriate. That sentencing a 13-year-old as an adult for crimes rooted in documented trauma and clinical disorder violated evolving standards of decency under the Eighth Amendment. She was a good lawyer making the best available argument. She knew what she was working with. She worked with it anyway because that is what the system requires of its defenders, and because the argument had genuine legal merit regardless of the evidence's weight. The certification hearing lasted 3 days. The judge presiding, not Judge Calloway who would preside over the trial itself, but a senior colleague, listened to developmental psychologists on one side and the forensic examiner on the other and asked, by the court reporter's count, 47 questions. She was thorough. She was clearly troubled. Her ruling, issued in writing 4 days after the hearing closed, was that the boy would be tried as an adult. The language she used became widely cited. The severity of the acts, the evidence of planning, and the clinical assessment of the defendant's profile collectively exceed what the juvenile system was designed to address. The community response to certification split along lines that mapped, roughly, onto existing divisions about how the justice system should handle young people who do terrible things. Those who had known Harold and Evelyn, most of the community, were largely relieved. Child advocacy organizations filed formal objections and organized a press vigil outside the courthouse. The boy's story was briefly adopted as a cause by groups who argued, with some accuracy, that the system had failed him long before he failed Harold and Evelyn, and that adult prosecution compounded failure with failure. Both positions were argued publicly and sincerely. The judge had made her ruling. The positions would continue to be argued long after the trial. At the arraignment, the boy stood very still while the charges were read. 2 counts of first-degree murder. His attorney answered for him when the judge asked if he understood the charges, standard procedure. But the boy, unasked, also nodded. Slowly. The kind of nod that contained something private. Several people in the gallery noticed it. No one was entirely sure what it meant, and that uncertainty was itself significant. This was a child whose internal state remained opaque to everyone in the room, including, it seemed, to himself. Harold's daughter, the boy's mother's sister, who had flown in from another state and had not spoken publicly, sat in the second row of the arraignment gallery. She had issued one written statement through the Victim Services Office. Harold and Evelyn were not symbols or subjects for debate. They were people who spent their last 8 months trying to help a child. We ask that they be remembered for who they were, not for how they died. The statement was read into the courtroom record by the victim advocate. The boy did not look in her direction. Trial was set 7 months out. Those 7 months were spent in pretrial motions, evidence challenges, psychological evaluations, and a sustained, structureless grief that the community carried without anywhere to put it. Harold's workshop sat locked. Evelyn's journal sat in an evidence box. The chess game remained mid-move on the dining room table. The birthday card sat in a box of belongings that no one could bring themselves to touch. Then, 6 days before trial, the prosecution received the final processed item from the boy's journal. A handwritten timeline, dated 6 days before the killings, of the events of that Thursday night. Written before. Ink analysis confirmed. A plan. The prosecutor looked at it for a long time in her office that evening. Then she turned off her desk lamp and rewrote the opening of her closing argument on a gray Tuesday in February. Every seat in the gallery was taken. A dozen media outlets had credentials. 2 sketch artists had positioned themselves for clear sight lines to the defense table. Security had been increased after threats, not against the boy, but against the legal system for, in the sender's view, allowing Harold and Evelyn to die without intervention. Judge Margaret Calloway entered at precisely 9 a.m. and the room stood. She had been on the bench for 19 years. She ran a quiet courtroom. She had once held an attorney in contempt for arriving 4 minutes late. The room knew this. The room stood very still. Judge Calloway was known in legal circles for 2 things: meticulous preparation and absolute zero tolerance for courtroom theatrics. She had a daughter who was 13 years old, a fact disclosed during voir dire that both sides had agreed did not require recusal. This detail was noted, filed, and not discussed publicly during the trial. It was not nothing. A judge who understood at a cellular level what 13 looked like was presiding over a case that asked what 13 could do. The prosecution's opening statement was 18 minutes long and contained no rhetorical ornament. The prosecutor walked the jury through a sequence: phone records, search history, gunshot residue, the pre-written timeline. She described the victims with care and brevity: Harold's workshop, Evelyn's library, the chessboard, the birthday card. And then she said, "This case is not about a child who made a terrible mistake in a moment of fear or confusion. The evidence will show that this was planned, that it was carried out, and that in the 90 minutes that followed, the defendant demonstrated not distress but completion." She sat down. The room exhaled in the particular way rooms exhale when someone has said exactly what needed to be said. The defense attorney's opening was 26 minutes. She built a scaffolding of context that was legally sound and humanly compelling. The trauma history, the clinical diagnoses, the developmental science establishing that the adolescent prefrontal cortex, the region governing impulse control and moral reasoning, does not fully mature until the mid-20s. A 13-year-old brain is constitutionally incomplete, she argued. The law had recognized this in decades of evolving jurisprudence. Trying this boy as an adult treated an incomplete moral agent as a finished one. Several jurors leaned forward. The argument had merit. It would not be enough. The boy's courtroom presence became a recurring element of the trial's texture, noted by reporters, sketch artists, and jurors alike. He sat very still. He appeared to take notes on a legal pad. He rotated through shirts, blue, white, gray, the wardrobe of a school student. He watched witnesses with the focused, slightly tilted attention of someone watching a documentary on a subject they find interesting. He was, by all accounts, the least visibly frightened person in the room. One juror, in post-verdict media interviews, said, "I kept waiting for him to break. Even a little. He never did." The first witness was the neighbor who had called in the welfare check. She was 61 and had known Harold and Evelyn for 9 years. She described the night accurately and calmly. Then the prosecutor asked her one final question. In 9 years of knowing them, had she ever heard or seen anything that concerned her about the household? She said no. She said they were the kind of people who shoveled your walk without being asked and didn't mention it afterward. She was excused. She walked past the defense table without looking at the boy. He watched her go with the same attentive, slightly tilted expression he gave every witness. The sketch artist's hands moved. The lead detective took the stand on day 2 and testified for a day and a half. She walked the jury through the investigation with the precise, unhurried detail of someone who had documented everything and forgotten nothing. The jury heard the text messages read aloud. They saw the search history on a projected screen. They heard the phrase, "How do people act when they are innocent?" in the detective's flat, professional voice. Several of them shifted in their seats in a way that the trial observer from the regional newspaper would later describe as the moment the room decided. Then the prosecutor asked the detective about the pre-written timeline found in the journal. The defense objected. The challenge had been litigated and denied in pretrial. The judge overruled without looking up. The detective opened her folder. The courtroom went very still. The next chapter begins before she reads the pages in pencil. The ink analysis had confirmed it was written 6 days before the killings. The detective read it aloud in the flat, measured voice of someone who has learned that removing emphasis lands harder than adding it. The courtroom was so quiet that the court reporter later said she could hear the scratch of the sketch artist's pencils. The document was structured like a project plan. It listed times, actions, contingencies. It had a section in the boy's own hand, labeled, "If they wake up early." He had planned for that possibility. He had planned for several possibilities. The plan was not impulsive. It was considered. The jury's reaction to the reading was documented by trial observers with the discipline that the room required. No outbursts, no audible responses, but a series of micro-shifts. A juror pressing their lips together. Another staring at the exhibit screen with an expression that had passed beyond shock into something quieter and harder. A third writing on their notepad with so much force the pen nearly tore through. The foreperson, who had maintained practiced neutrality for 6 days of testimony, turned and looked directly at the defendant. He was looking at the exhibit screen. His expression did not change. He watched it the way he watched everything. Attentive, neutral, somewhere between present and not. The defense's cross-examination of the detective on this point was careful and well-constructed. The attorney asked whether, in her training and experience, she had encountered juveniles who produced what clinicians called fantasy documents, plans, scripts, rehearsal writing that represented thought rather than operational intent, never meant to be acted upon. The detective said yes, she had encountered such documents. The defense asked whether this document could be such a document. The detective paused for exactly one beat before answering. In every case where I have encountered such documents, the events described in them did not subsequently occur. In this case they did. The defense had no follow-up question. In a choice that was legally sound and emotionally precise, the prosecutor then asked to read a passage from Evelyn's journal, Exhibit 14, already admitted into evidence. The defense objected on relevance grounds. The judge overruled. The prosecutor read the final entry, the observation that the boy had seemed distant at dinner, the plan to call the school counselor in the morning, and then the last line, "Something is off. I'm going to find out what." She set the journal down. She turned to face the jury. She said, she was right. She never got the chance to find out. She sat down. The defense asked for a brief recess. The judge granted 5 minutes. Prosecutors played a forensic reconstruction video on day 3, a digital model built from blood spatter analysis, trajectory data, and room dimensions, walking the jury through the sequence of events on the night of the killings. The video was 6 minutes long. Clinical. Silent except for the forensic narrator's voice. 6 minutes is a significant amount of time to watch something like that in a quiet room. Several jurors did not watch all of it. They looked at their hands or the floor or the window. The boy watched the entire 6 minutes without looking away. Without changing expression. The prosecution played the audio of the second police interview, the one conducted after the search history had been revealed to the boy, when his original story began to fragment and shift. The jury heard his voice for the first time, calm, adaptive, constructing and partially abandoning a revised narrative in real time. And then they heard the moment, documented, on record, unambiguous, when the detective told him that Harold and Evelyn's family needed to understand what happened, and he said, "People die." In the gallery, Harold's daughter stood, walked to the aisle and left the courtroom. The judge paused the proceedings for 2 minutes. She looked at the door through which the daughter had gone. Then she called the session back to order. The defense's case took 2 days. Developmental psychologists testified about the science of adolescent brain development, about the documented effects of early trauma on moral reasoning, about the existing legal precedent treating juvenile defendants as categorically different from adults. Their testimony was credible and peer-reviewed. It described something real. It described a category, adolescents with trauma histories and clinical profiles, and the evidence described a specific person within that category who had gone, by every documented measure, further than the category predicted. For the jury, several of whom spoke to press after the verdict, the science and the evidence were not in contradiction. The defense announced they were simply describing different things, would not and testify. Only one of them had Exhibit 47 attached to it. The decision was legally sound. The Fifth Amendment right is absolute, and submitting the boy to cross-examination by a prosecutor holding Exhibit 47 and the interview audio would have been strategically ruinous. But the announcement still moved through the gallery with a specific kind of unsatisfied energy. People had come, in part, to hear him speak. To find in his own words some architecture for comprehending what had happened. His silence denied them that architecture. It also may have been the single most strategically correct decision made on his behalf throughout the entire proceeding. Jurors are instructed not to draw negative inference from a defendant's choice not to testify. They are also human beings. In post-verdict interviews, 3 separate jurors referenced the silence, carefully with the awareness that they were not supposed to hold it against him legally, but with the candor of people who had sat in a room with that silence for days. One said, "I kept thinking, if there's anything to say, any context, any explanation, he has the right to say it. He chose not to. I wasn't holding it against him legally. But it told me something about what he thought was worth saying." The prosecution's closing argument was 44 minutes. It began with Harold's workshop, the sawdust, the coffee cooling on the windowsill, the furniture built for neighbors who never knew who built it, and it ended with Evelyn's last journal entry. In between, the prosecutor walked through every piece of evidence with the patience of someone who understood that the jury did not need convincing of the facts. They had the facts. They needed a frame. "You have heard every argument for why this should be understood as something other than what it is," she said near the end. None of those arguments change the entries in that journal. None of them change the text message. None of them bring Harold and Evelyn Marsh home. The defense closing was 31 minutes and was, by legal observers' accounts, the most skilled advocacy of the trial. The attorney did not minimize the deaths. She did not argue innocence. She argued that the boy before them was not a fully formed moral agent, that his brain, his history, and his clinical profile had conspired to produce something that the juvenile system had been built precisely to address. She argued that trying him as an adult was the justice system's oldest error, treating a person for what they are as if it were simply a choice. Several jurors had tears during her closing. The boy looked at his notepad. The jury deliberated for 11 hours and 22 minutes across 2 days. They requested 3 readbacks: the detective's testimony about the pre-written timeline, the forensic psychologist's distinction between knowing wrong and feeling it, and the audio clip of the interview in which the boy said, "People die." These 3 readbacks tell their own story about where the jury's doubt had gathered and where it ultimately resolved. Guilty. 2 counts of first-degree murder. The word arrived in the courtroom without drama. It had been anticipated by most observers, and anticipation blunts the acoustic impact of even the most significant moments. Then the stillness came. The kind of stillness that follows a verdict when the word is accurate and everyone in the room knows it, and knowing it does not make it easier because nothing makes it easier. Harold's daughter was back in the gallery. When the verdict was read, she closed her eyes. She kept them closed for a long time. The boy's reaction, still. His attorney placed a hand on his arm. He looked at the hand for a moment, the way he examined all data points, registering it, filing it. He did not cry. He did not react to the verdict with any visible emotion. He did not look at the gallery. He did, 3 reporters in the front press row noted in their independent accounts, glance at the door, briefly, as if noting its location. Then he looked forward again. The smirk was not there. But neither was anything else. Sentencing was set for 6 weeks out. The gavel came down. The session adjourned. The lead detective stood on the courthouse steps for a moment before walking to her car. A reporter asked how she felt. Opened with victim impact statements. "I feel like Harold and Evelyn got architecture of a murder trial. I'll figure out the rest later." These statements serve a legal function, providing the sentencing judge with context about the harm caused. In human terms, their function is something else entirely. They are the only moment in the entire proceeding where the victims are not exhibits, not entries in the record, not names in the caption. They are people, in the mouths of people who love them, addressed directly to the person who erased them. The law makes space for this. The space is never large enough. Harold's son stood at the podium with hands that were visibly unsteady and a piece of paper he had folded and refolded until the creases had softened. He spoke for 7 minutes. He talked about the workshop, the furniture built for neighbors who never knew who built it. He talked about the last phone call, an ordinary call about a football game, the kind that you don't archive in your memory because you assume there will be hundreds more exactly like it. "I don't have a last conversation," he said. "I have a regular conversation that became the last one without any warning." He folded the paper. He did not look at the boy. He sat down. Evelyn's sister came to the podium carrying one of the 37 journals, not to read from it, but to hold. She spoke about who Evelyn was in the world with the particular precision of someone who has been preparing the sentences for months, running them over and over, trying to get them right. The librarian who stayed late to help kids find books about things they were afraid to ask their parents. The sister who called every Sunday without exception. The woman who had, in the last 8 months of her life, chosen to love a child who was difficult because she believed, as she had always believed, that love was the correct response to difficulty. She was right to believe that, the sister said. She was just wrong about who she was dealing with. A statement co-signed by 41 former colleagues and 73 former students from the library where Evelyn had worked was submitted in writing and read into the record by the judge. It described the specific quality of Evelyn's presence in that building, the way she could find the right book for the right child at the right moment, the way she treated every kid who walked through the door as someone whose interior life deserved to be taken seriously. She had a gift for meeting people where they were, the statement read. Including, it appears, the person who killed her. The defense presented mitigation, clinical reports, documentation of early trauma, and the testimony of a social worker who had been assigned to the boy's case when he was 8 years old. She described, with visible difficulty, a child who had been let down by nearly every system designed to help him before arriving at Harold and Evelyn's door. She did not argue that the killings were justified. She argued that they were, in some measurable sense, predictable, and that the predictability was itself an indictment of everything that had come before. The room was quiet differently during her testimony, the quiet of people encountering complexity they had not fully admitted. The court gave the boy the opportunity to speak before sentencing. He took it. He stood at the podium in the blue shirt and read from a prepared statement for 2 minutes. The language was calibrated. The forensic psychologist would later note it had the cadence of something practiced rather than felt. He said he understood the harm and was sorry for the pain of the families. The statement contained no specific memory of Harold. No specific memory of Evelyn. No detail that indicated he had known them as people rather than as circumstances. Harold's son, sitting in the gallery, covered his face with his hands. Not at what was said. At what wasn't. When the boy finished and sat down, the court reporter noted a silence of approximately 12 seconds. 12 seconds is nothing. 12 seconds in a room that quiet is a very long time. The judge looked at her notes. She looked at the boy. She looked at the gallery. Then she did something she did not normally do. She placed her notes flat on the bench in front of her, lifted her glasses from her face and set them beside the notes. She leaned forward slightly toward the microphone. The sketch artists raised their pencils. The recorders ran. The gavel sat untouched on the bench. And she began to speak. Judge Calloway began with the law because the law is where she lived and where the proceeding required her to begin. She cited applicable statutes. She addressed the sentencing range. She walked through the factors the court was obligated to weigh: the severity of the offense, the history and character of the defendant, the need for the protection of the public, and the question of whether rehabilitation was a realistic outcome in a realistic timeframe. This portion of her statement was approximately 3 minutes long and was delivered in her normal, measured cadence. A judge performing the function she had performed hundreds of times. And then she stopped. She removed her reading glasses. She set them on the bench beside her notes. 3 reporters noted this simultaneously in their notebooks. It was unusual enough to register. She looked at the defendant, directly, without the mediation of the glasses or the document, and said, "I am going to say something to you directly before I pronounce sentence, because I believe it matters that you hear it from a human being and not a document. You are 13 years old," she said. "I have a daughter who is 13 years old. And I want you to understand that when I look at you, I do not see a monster. I see a child who was failed, by circumstance, by systems, by people who should have intervened and did not. I see all of that clearly and I have thought about it throughout this entire proceeding. I also see Exhibit 47. I see the search history spanning 11 days. I see a timeline written in advance and executed precisely. I see a text message sent 90 minutes after 2 people died that said the word, 'done.' I see a child who planned the deaths of 2 people who had chosen to love him. I need you to understand that I see both of those things simultaneously, and that the law requires me to respond to both. The argument has been made," she continued, her voice steady, "that the juvenile system was designed for cases like yours. I have thought about that argument every day of this proceeding. The juvenile system was designed for children who made catastrophic mistakes, who acted without thinking, without planning, without foreseeing consequences, and who deserved the chance to become someone different because their act was the act of an incomplete person in an uncontrolled moment. What the evidence in this case describes is not that profile. What the evidence describes is 11 days of research, 6 days of scheduling, a written contingency plan, and 90 minutes of aftermath management. That is not impulsivity. That is not the failure of an incomplete brain to resist a momentary impulse. That is the use of a developing brain, over an extended period, to plan and execute a predetermined end." Then she paused. She looked for a moment at the gallery. At Harold's daughter in the second row. At Evelyn's sister with the journal in her hands. Then she looked back at the boy and said the words that 14 million people would watch within a week. Harold Marsh built things for people who couldn't afford them and he never told anyone. Evelyn Marsh found the right book for the right child at the right moment for 18 years. They spent the last 8 months of their lives choosing you. I'm going to say that again. They spent the last 8 months of their lives choosing you. She paused again. The least I can do in this courtroom is say their names. The sentence was 2 consecutive life terms with a minimum of 50 years before parole eligibility. Under its terms, the boy would be 63 years old at minimum, before a parole board would consider his case. He would serve more years in prison than Harold and Evelyn had spent in the house they loved. The numbers settled into the courtroom like a new kind of architecture, something built to last. Before closing, the judge addressed the gallery directly. "The law asks me to sentence a defendant. I also want to acknowledge the people who are not in this room anymore. Harold and Evelyn Marsh were not symbolic. They were specific. They had a workshop in a library and 37 journals and a chess game that was never finished. This court has heard them as clearly as it is possible to hear people who can no longer speak for themselves. I hope that is something." She picked up the gavel. She held it for a moment. She brought it down once, clean and final. The echo of it moved through the room. The session was adjourned. And the boy, as the marshals arrived at his side, looked, for the first documented time in the entire proceeding, as if something had reached him. Not grief. Not remorse. But the first faint, arriving recognition that the world he had built in his journal, the world where he was in charge, had just been replaced by a different one. Built by other people. For the rest of his life. The day after sentencing, the smirk was gone. The street where Harold and Evelyn had lived was quiet in the way streets are quiet after something has been concluded but not resolved. The lead detective arrived at her office to file her closing paperwork. The prosecutor fielded calls from media. The defense attorney sat at her desk with a case file she did not immediately know what to do with. Harold's son flew home that morning to a house where his father's work boots were still in the closet. None of these moments were dramatic. That is the point. Justice, when it arrives, does not arrive with the emotional resolution of a film's final frame. It arrives as a legal document and a changed institutional status. The grief underneath it does not reorganize itself to match. Harold and Evelyn's house sat empty for 4 months while the estate was settled. During those months someone, no one ever confirmed who, continued to keep the front walk clear of leaves and snow. Quietly, without announcement, without acknowledgement. The neighbors noticed. No one asked. Sometimes the weight of an unknown act exceeds the weight of a known one. The defense attorney gave one brief public statement 2 weeks after sentencing. She said she stood by her arguments and believed the legal questions raised by the case remained important for the broader conversation about juvenile justice. She said she hoped the sentence would be reviewed when the boy was older, when the developmental science had further matured, when the courts had better tools. She also said, and this was not part of her legal argument, she acknowledged, that she hoped he would someday understand what he had done. Understanding it legally and understanding it morally are different things, she said. I don't know if he'll ever get to the second one. I hope he does. The forensic psychologist who evaluated the boy published an academic paper 2 years later, with identifying details altered, examining the case as a model for early identification of high-risk juvenile profiles. She argued for earlier and more intensive clinical intervention. She argued that the gap between a documented concern notation and a scheduled evaluation, 2 weeks in this case while events moved faster, was too wide a gap for children at the clinical extreme. She was careful not to claim the outcome was certain to have been preventable. She argued it could have been better contested. The paper was cited 31 times in the year after publication. Evelyn's 37 journals were returned to her family after the trial concluded. Her sister kept them. She has described the process of reading them as one she has returned to over years, 1 or 2 entries at a time when she feels ready. Reading them, she said in an interview, is the experience of hearing Evelyn's voice with full knowledge of the silence that follows it. Painful and necessary simultaneously. She was paying attention to everything, the sister said. She deserved for everything to pay attention back. Harold's son took the chessboard when the house was cleared. He told his wife he wasn't sure why he needed it. She said she understood anyway. It sits on a shelf in his study, not set up, not mid-game, pieces stored in their velvet case inside the box. I couldn't put it away entirely, he said in the only statement he ever made about it. And I couldn't finish the game. It sits where it sits. That is where it is. The boy, growing older now, inside walls in a world built by the consequences of what he did at 13, has had no major disciplinary incidents per public record. He participates in educational programming. The outline of his days is institutional and regular. Whether this represents change or adaptation, or something the clinical vocabulary does not yet have a precise word for, no one outside the facility knows with certainty. What is documented is the surface. What happens under the surface of a life served in those conditions over those years, with that history, remains genuinely unknown. The case is closed. The questions it generated are not. Cases involving juvenile defendants tried as adults occupy a specific and pressurized position in the American legal conversation. They sit at the intersection of neuroscience, criminal justice, moral philosophy, and the kind of visceral public response that defies easy categorization. This case intensified every dimension of that conversation. It was picked up by legal scholars, child advocacy groups, developmental scientists, victims' rights organizations, and true crime audiences, each of whom engaged with it through a different primary question, and none of whom arrived at the same answer. The developmental science presented in the boy's defense was not invented for the occasion. It is peer-reviewed, replicated across multiple research populations, and broadly accepted within the fields of adolescent neurology and developmental psychology. The adolescent prefrontal cortex, governing impulse control, risk assessment, and moral reasoning, continues developing until the mid-20s. This is not an argument. It is biology. The debate was not whether the science was real. The debate was what the law was required to do when the science was real and what happened also happened. The prosecution's implicit rebuttal to the developmental argument was direct and specific. The science describes a deficit in impulse control. This case contained no impulse. It contained 11 days of research, 6 days of scheduling, a pre-written contingency plan, and 90 minutes of calculated aftermath management. Whatever the boy's prefrontal cortex was or was not capable of in terms of spontaneous emotional regulation, it had been deployed over an extended period to produce an extended, deliberate plan. The science and the facts were not in conflict. They were describing different things. The jury determined which description was legally operative. The social worker who testified at sentencing gave the systemic question its most direct articulation. If intensive clinical intervention had occurred at age 8, when documentation of concerning behavior first appeared in the record, what might have been different? No one can answer that with certainty. What is certain is that the documentation existed, that the system moved at bureaucratic speed, and that events moved faster. Multiple child welfare organizations cited the case in subsequent advocacy for faster mandatory response timelines for flagged clinical concern notes. One state reduced its required response window. It is a small change. It is not nothing. Harold and Evelyn's family, in the limited public statements they made, articulated a dimension of the debate that received less coverage but was no less real: the experience of being the family of victims whose case has become a cause. Of watching the people you lost become secondary to the arguments about the person who took them. Harold's daughter said in one interview, "I understand why people want to have the bigger conversation. I just wish the bigger conversation had happened before it needed 2 dead people to start it." Judge Calloway gave one extended interview, published in a legal journal approximately a year after sentencing. She addressed the tension she had named from the bench, seeing both the failed child and the committed act simultaneously, with the candor of someone who had thought about it carefully for a year. She said, "The law gave me a framework. The framework did not make it easy. I believe the sentence was correct. I also believe that correct and sufficient are different words, and I don't think any sentence in this case was sufficient for what was lost." She mentioned that her daughter's school photo was still on her desk. She did not elaborate on why she mentioned it. The discussion triggers that this case generates are not rhetorical. They are genuine. Was justice served? The legal mechanisms functioned. The evidence was heard. The verdict was returned. The sentence was imposed. If justice means proportional accountability within the law's framework, then yes, it was. But if justice means restoration, repair, return of what was taken, then no verdict in any courtroom can deliver it, because Harold and Evelyn Marsh cannot be restored. Both of those things are true. The audience that has followed this story to this chapter has the right to sit with both of those truths and decide for themselves what the word justice means to them. The comments below this story have been full of that conversation. 50 years before parole eligibility. He was 13 at sentencing. He will be 63 at minimum before a parole board considers his case. The mathematics of that sentence are not abstract. He will spend more of his life inside walls than Harold and Evelyn spent in the house they had lived in for 31 years. He will be older when first eligible for parole consideration than Harold was when he retired and built his workshop. The numbers are not symbolic. They are the actual measurement of the consequence. Per public record, his years in custody have not been marked by the dramatic behavior that sometimes characterizes high-profile juvenile killers in adult facilities. He has completed his GED. He participates in vocational programs. He has had no major disciplinary incidents. In a system designed, in many of its dimensions, to warehouse people, he has not been entirely warehoused. Whether this represents genuine change, a developing moral architecture that did not exist at 13, or adaptive behavior, or something the clinical vocabulary doesn't yet have a precise word for, no one outside the facility can say with confidence. The surface is documented. The interior remains opaque as it was from the beginning. The parole board that will eventually review his case, 50 years from sentencing, composed of members who are children now or not yet born, will face a version of the same questions Judge Calloway faced. Can the man he will have become in 5 decades of incarceration be meaningfully separated from the boy who planned those deaths at 13? Should it be? The law will require them to answer. The answers will be contested. That is the nature of decisions made at the intersection of what people did and who they became. Harold's workshop no longer smells like sawdust. The house has been sold, the garage converted to a home office by a family who moved in 4 years after the killings and does not know the full history of the walls they painted. The workbench is gone. The tool pegboard replaced by storage shelving. There is no coffee cooling on the windowsill. The outline holds this not as tragedy but as the natural entropy of time. Houses continue. Rooms become other rooms. The people who worked in them do not. The sawdust smell is gone. Harold is not replaced by its absence. He is simply absent. The library where Evelyn worked for 18 years has a small brass plaque bolted to the wall beside a reading corner named for her. Her recommendation system, color-coded tabs indicating which books she personally matched to different kinds of readers, has been maintained by the current librarians. Several of them do not know its origin. A few do. The books continue to be found by the children who need them. She would have considered that sufficient. Harold's son was asked by a journalist 2 years after sentencing whether he felt the case was closed. He said, "The legal case is concluded. What happened to my parents will never be closed for me. And I'm okay with both of those things being true at the same time. The court did its job. My job is different. My job is to keep remembering them correctly, not just as victims but as who they actually were. That's the job I have for the rest of my life." He did not say it was a burden. He said it was a job. The distinction matters. The outline returns for a final moment to Evelyn's 38th journal, found half full in her nightstand, the final entry dated 2 days before her death, blank pages remaining after it. She had been in the middle of something. She was always in the middle of something. The journal sat in an evidence box for the duration of the trial and was returned to her sister after the verdict. Her sister has not written in it. It is not hers to write in. But she has kept it beside the other 37 on the shelf in her living room, in sequence, in order, the way Evelyn kept everything. The story began with a smirk. A 13-year-old boy in a courtroom built for adults, in a shirt 2 sizes too large, looking at a gallery full of grief with a slow, deliberate curl of the lip. The expression of someone who believed he had built something untouchable. He had spent 11 days researching, 6 days planning, 90 minutes managing the aftermath, and the weeks that followed performing a version of innocence he had researched specifically on the phone that kept every search. He smirked because he believed the performance would hold. He believed he was smarter than the room. He was not smarter than the room. He was not smarter than 37 journals kept by a woman who paid attention to everything. He was not smarter than a phone that kept records he thought it didn't keep. He was not smarter than a forensic technician who knew what gunshot residue looks like even after someone has tried to wash it away. He was not smarter than a lead detective who documented everything, forgot nothing, and answered his attorney's most strategic question with, "In every case I've encountered documents like this, the events they described did not subsequently occur. In this case they did." He was not smarter than a judge who took off her glasses and said the names of the people he had erased, and then brought the gavel down. Harold Marsh built furniture for people who couldn't afford it and told no one. Evelyn Marsh found the right book for the right child at the right moment for 18 years. They spent the last 8 months of their lives cleaning out a spare room, buying new bedding, enrolling a troubled boy in a nearby school, teaching him chess, framing his school photo, and writing him a birthday card that said, "We're so glad you're here." They chose him. That choice is not diminished by what he did with it. It is not undone. A choice made from love does not become something else because the person it was extended to betrayed it. It remains what it was, generous, clear-eyed, and worth documenting. This case established several things simultaneously. It established that a 13-year-old can plan and execute first-degree murder and that the legal system can respond to that fact with the specificity and moral weight it deserves. It established that digital forensic evidence, search history, text messages, timestamps, ink analysis, can reconstruct not just what happened but what was intended, and that intention matters in a courtroom in ways that cannot be legislated away. It established that a judge can hold complexity, the failed child and the committed act, and still find, within that complexity, a clear sentence. And it established, most quietly, that 2 people named Harold and Evelyn Marsh, who spent their lives paying attention to the world and choosing generosity within it, deserved to be named in open court by someone with the authority to make the naming mean something. The discussion this story generates is not incidental to its meaning. It is the meaning. Was justice served? The mechanisms functioned. The evidence was heard and weighed. The verdict was correct by every legal standard. The sentence was the maximum the law permitted. If justice means proportional accountability, then yes, the system delivered it. If justice means restoration, then no courtroom anywhere can deliver it for Harold and Evelyn Marsh, because restoration is not possible. Both of those things are true simultaneously. The question of which definition of justice you hold, and whether a legal system can satisfy it, is a question worth carrying into the comments, into conversations, into the larger ongoing human argument about what we owe each other and what we do when that debt is violated. Pushpin, if you believe that accountability matters, that Harold and Evelyn Marsh deserve to be remembered, share this story. The people who needed to see it most may not have found it yet. The courtroom is empty now. The sketch artists are gone. The reporters have filed their stories. The gallery has cleared. The judge's bench is quiet, the gavel lying flat. Through the courtroom window, a street is visible, wide enough for children to ride bikes, mature trees, houses set back from the road in the afternoon light. Somewhere in that direction, a library has a brass plaque on a wall and a recommendation system maintained by librarians who may or may not know whose system it is. Somewhere in that direction, a chessboard sits in a velvet case inside a box on a shelf in a study. The gavel fell. The smirk disappeared. Harold and Evelyn Marsh were named in open court by a judge who removed her glasses to do it. The blank pages at the end of the 38th journal remain blank. She was always in the middle of something. The session is adjourned.